Our homeowners association dues just went up for the third time in 2 years, yet the neighborhood pool was closed. The landscaping was dying, and the streetlights were broken. Everyone thought it was just terrible management. But when the HOA president tried to foreclose on an elderly widow over $45 in late fees, I decided to look at the public tax filings. What I found wasn't just mismanagement. It was a $50,000 heist, and I had the receipts to prove it. I live in a mid-sized suburban neighborhood with about 200 homes. For the last 3 years, our HOA president, let's call her Brenda, ruled the neighborhood like a dictator. She would measure the height of your grass with a ruler and fine you $50 if your trash can was visible from the street. But while she was ruthlessly fining the residents, the neighborhood reserve fund was mysteriously draining. The breaking point happened last month. Brenda sent a foreclosure notice to Mrs. Higgins, an 80-year-old widow on a fixed pension, over a disputed $45 landscaping fee. When the neighborhood found out about Mrs. Higgins, people were furious. But Brenda just smirked at the monthly board meeting and said, "The bylaws are the bylaws. If you don't pay, you lose your house." That night, I couldn't sleep. I knew that HOAs are legally classified as nonprofit corporations, which means their financial records are supposed to be transparent. I went to the state's corporate registry website and pulled the HOA's last 3 years of public tax filings, specifically the Form 990. I started comparing the official vendor payouts against the invoices Brenda had posted in our private community portal. Let's pause and talk about the law, because Brenda was about to learn a very painful lesson about something called fiduciary duty. When you sit on an HOA board, you are legally bound by a fiduciary duty to the homeowners. This means you must act in the best financial interests of the community, not yourself. If a board member uses HOA funds for personal gain, it crosses the line from a civil dispute into criminal embezzlement. Furthermore, most states have strict laws preventing HOAs from foreclosing on a primary residence over minor, disputed fees. Brenda wasn't just breaking the bylaws, she was breaking state and federal law. I spent 4 hours cross-referencing the documents, and then I found it. The HOA had paid $25,000 to a company called BR, Consulting for Community Management Software. I searched the state business registry for BR Consulting. It was a shell company, registered to Brenda's husband. I dug deeper. There was another $15,000 paid to a landscaping consultant, whose listed address was Brenda's brother's house. She had siphoned at least $50,000 from the reserve fund, while trying to take an elderly widow's home over $45. I didn't post it on Facebook. I didn't yell at her in the street. I printed out 50 copies of the state registry documents, the tax filings, and the shell company certificates. I walked into the next emergency HOA board meeting, handed a stack of papers to every single homeowner in the room, and handed the original folder to the police officer I had asked to wait outside. The room went dead silent. Brenda turned completely pale. The property verdict? Brenda was immediately removed from the board by a unanimous vote. The district attorney opened a formal investigation for embezzlement and fraud. Mrs. Higgins kept her house, and the new board slashed our monthly dues by 20% once the bleeding stopped. If you live in an HOA, remember that you have a legal right to audit the books. Never let a bully with a clipboard steal your equity. Hit subscribe for more property justice, and I will see you in the next case.